What is a DWAI? Under New York Vehicle and Traffic Law Section 1192, it is illegal to operate a motor vehicle while your ability is impaired by alcohol, drugs, or both. A DWAI by alcohol does not require a specific blood alcohol content and can be proven by any degree of impairment, whereas a DWI requires a blood alcohol content of 0.08% or higher. New York defines operate broadly, so you can be charged if you are behind the wheel with the engine running even if the car is not moving. There are three categories of DWAI, covering impairment by alcohol, by drugs, and by a combination of both. Penalties for a first DWAI by alcohol include fines up to $500, up to 15 days in jail, and a 90-day license suspension. Penalties for a DWAI by drugs or combination are harsher because they are misdemeanors, with fines up to $1,000, possible jail up to a year, and a 6-month revocation. Repeat DWAI offenses increase fines and jail time and can elevate an infraction to a misdemeanor, and causing an accident or carrying a child under 15 can turn the case into a felony under Leandra's law. Each conviction triggers a driver responsibility assessment of $250 annually for 3 years, adding extra costs on top of court penalties. Prosecutors use slurred speech, bloodshot eyes, the smell of alcohol, unsteady movement, and field sobriety tests to prove impairment, but a defense attorney can challenge whether the stop was lawful and whether tests were administered correctly. Breathalyzer machines must be properly calibrated and blood samples must follow chain of custody rules, so unreliable chemical tests and evidence of rising blood alcohol content can provide a defense. A DWAI conviction stays on your Department of Motor Vehicles record for 10 years, raises insurance premiums, and can affect employment. And while New York does not expunge convictions, some people may seek sealing under Criminal Procedure Law Section 160.59 or the Clean Slate Act that began implementation in November 2024. In some cases, prosecutors agree to reduce a DWI to a DWAI by alcohol, which changes a criminal misdemeanor to a traffic infraction and lowers fines and license penalties. After an arrest, you will be arraigned in court, enter a plea, and the Department of Motor Vehicles may begin proceedings that could suspend or revoke your license, especially if you refused a chemical test. Before trial, your lawyer can file motions to suppress evidence and challenge the legality of the stop or the reliability of tests in an effort to dismiss or reduce the charges. Even though DWAI penalties are less severe than DWI penalties, a 10-year mark on your record and enhanced penalties for future offenses can affect your life for years. Choosing an experienced lawyer is important because an attorney who knows how prosecutors build impaired driving cases can challenge the evidence and negotiate effectively, and a knowledgeable law firm will be familiar with local courts and prosecutors. Jason Bassett is a former prosecutor with over 21 years of experience in criminal law and is admitted to practice in New York and federal courts. His law firm handles DWAI, DWI, and related cases throughout Suffolk County and Nassau County. The law offices of Jason Bassett, P.C., located at 320 Carleton Avenue No. 4200, Central Islip, New York, 11722, United States, can be reached at 631-259-6060. Call the law firm today to schedule a free consultation with an attorney and learn how a lawyer can help protect your rights and driving privileges under New York's DWAI laws.